Good afternoon. I'm Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We're delighted that you're able to join us virtually today for the first webinar in our special HIPAA webinar series. Today's webinar is being presented by Dr. Stacy Larson, who currently works as a psychologist in the VA, conducting disability, capacity, and clinical care assessments. Additionally, she is the chair of her VA hospital's Consultative Ethics Committee, conducts monthly ethics seminars for clinical trainees, and supervises trainees in conducting capacity and compensation pension evaluations. We're also fortunate to call her a wonderful consultant to the Trust, and we're glad to have her with us today. I know that you all have been asking for information on HIPAA, and we are just delighted to be able to provide you a two-part series by Dr. Larson. I know you'll learn a lot, and you'll have your slides available to you to review as you have more and more questions. So now, without any further delay, I will turn it over to Dr. Stacy Larson. Thank you, Dr. Larson.
Thank you, Jana. Hello, everyone. So welcome to HIPAA webinar, part one. We're going to do a bit of an overview just of HIPAA in general and the privacy rule today. I'm going to try to make things relatively straightforward with the understanding that no regulation or governmental thing is ever very straightforward. So we'll try our best. I've got a few housekeeping things to do here at the beginning. So one, I'm declaring that I do not have financial or other relationships with the manufacturers of any commercial services discussed in this educational activity, no conflicts of interest. And then our learning objectives today are to identify who must comply with HIPAA, and then two, the basic tenets of the privacy rule, those key terms and sort of patients' rights under HIPAA. So what I want to do first is kind of give you a little bit of history of the Health Insurance Portability and Accountability Act, or HIPAA. So it was created to improve that movability of health insurance coverage for employees between jobs, and designed to improve sort of efficiency and effectiveness of the healthcare system and modernize that flow of information. Of course, this was done in 1996, and then they created sort of three different rules to help with that. These three rules are the privacy rule, which compliance date it started in 2003, the security rule in 2005, and then the breach notification rule, which became effective in September 2009. And that was part of the HITECH Act, which HITECH, introduced in 2009, was to kind of push the providers, healthcare authorities to implement use of electronic health records and extend the HIPAA to business associates at that point. The next thing we have is that the omnibus rule in 2013 passed, and that filled in gaps, sort of cleared up gray areas, such as encryption standards or information related to business associates, new administrative procedures for technology, like people who use mobile devices for records rather than desktops or files. And so one thing that we're kind of waiting on, HIPAA, there was a notice of proposed rulemaking that was released in December of 2020. The comment period closed in May of 2021. And this notice kind of proposed some changes, clarifying and amending some existing provisions. It was going to expand circumstances under which information can be disclosed in an attempt to improve care coordination. Also wanted to strengthen patient access, and was looking to decrease administrative burdens, but unclear where that rule is currently. It kind of got derailed a little bit by COVID and other things coming up. And so right now, this presentation is going to focus more on what the current rule says. And obviously, as a new notice comes out, I'm sure we will all make sure that that information is shared with everyone. So just some definitions. Some of you might be very much aware of these, but I wanted to go over them. So a covered entity under HIPAA is a healthcare provider. That's pretty self-explanatory. Mental health, medical, all sorts of different providers, health insurance plans, Medicare, Medicaid, Blue Cross, Blue Shield. And then clearinghouses are all considered covered entities. A clearinghouse is a public or private entity that kind of works between providers and insurance plans. It sort of could be a billing service that the healthcare provider might submit the bill that goes to the billing service, they clean it up, and then they submit it to the health insurance plan on your behalf. They are receiving PHI, so that's why they are considered as well. Protected health information, PHI. So HIPAA is all about protecting that protected health information. So PHI is any data that relates to past, present, future health of a patient, providing care to a patient, past, present, or future payment for healthcare. Basically any data that identifies a patient or could be used to identify a patient, and that data which is transmitted or maintained. So transmitting it electronically, maintaining electronically. We'll talk a little bit about how even if you are doing things electronically, it applies to paper records. And then business associates, any individual or entity who performs certain actions on behalf of a covered entity. And we'll talk a little bit more about kind of business associates, but they could be billing agencies, things like that, somebody that you've hired to help your practice with certain aspects of your practice. So who must comply with HIPAA? Covered entities, we've already talked about that, are healthcare providers who conduct certain administrative and financial transactions in electronic form. So that could be sort of transmitting information to email, to cloud storage from a mobile device, using Wi-Fi networks. Billing insurance is a big one. Making benefit inquiries on behalf of a patient. So if you reach out to insurance, sending emails to the insurance company, making transactions on their website, verifying that somebody has insurance could even be a trigger. Who must also comply are those business associates. And this was added with high tech. And those are those individuals or entities that you may hire to assist with business operations. Like I mentioned, like with claims processing or billing or data analysis, or even those companies you might hire if you use cloud storage or any sort of hard paper storage, those companies as well. One thing to be clear is that a member of your workforce would not be a business associate. Business associates are really outside of your practice, outside of your office. Couple of other things that sometimes come up is those electronic form transactions. We don't see a lot of them anymore, but a paper fax is not an electronic transmission. However, computer generated faxes would be. So that's one little kind of nuance that has come up as technology kind of moves with us. And anytime you're working with a business associate, that individual that's kind of you're hiring to help with PHI, you're going to want to have a business associate agreement, which kind of talks about the handling of the PHI, how the business associate is going to handle it. If there's an exposure, how the business associate would let you know, just kind of how they will use the data and will not use the data. So after you trigger HIPAA, after you do that electronic transmission, you're going to be required in conjunction with some sort of financial administrative issue, you're going to be required to comply with the 3 rules, the privacy rule, the security rule, and the breach notification rule. As I mentioned, this kind of is going to apply to all patients in your practice, even if you triggered for only one patient. So you might have never triggered HIPAA, you might have been completely paper, and then you email insurance potentially to talk to somebody or about a patient. You've now triggered it, and now everybody has to be kind of covered. Once you have triggered HIPAA, it applies to paper records as well as electronic records. So obviously these things are not exactly the same, but it comes down to kind of protecting the PHI, and whether it is in paper or electronic, the HIPAA is going to ask you to do both and make sure that it's not being disclosed in improper ways. So what happens if you don't comply with HIPAA? So the main risk is enforcement action from, sorry, an ambulance just went by. The main risk is enforcement action from the Department of Health and Human Services or state attorneys general. The Health and Human Services Office for Civil Rights is responsible for enforcing the privacy and security rules. They do this in many multiple ways. They might investigate complaints that are filed with them. They conduct compliance reviews to determine if covered entities are in compliance. They will perform education and outreach to foster compliance with rules requirements. They'll try to do a lot of education. They do, that's generally their main operandus. But there is a system of penalties that can go with this, ranging anywhere from 100 to 50,000 per violation. One violation would get $100. So let's say you had a cell phone or a laptop that had unencrypted patient information on it. Each person counts as a violation in that theory. So it could be up to, let's say you had 25 people's PHI on there. You could be paying up to 2,500 or more, depending on kind of how it is. And I'm not meaning to scare people. It's just to give an example. Penalties increase as the violation is deemed more willful and when it's not promptly fixed. So if you know that there's a problem and you don't fix it, that sort of willful neglect or an indifference to compliance, like, yeah, I know I need to lock my file cabinet, but I don't want to. That person might get a slightly higher penalty than somebody who's like, I've got my office door locked, I've got everything locked, they broke in, they got in, there's still an improper disclosure, but they tried to do what they needed to do. Or electronically, maybe they used an encryption or they showed that they couldn't use an encryption. And we'll talk more about that in the security rule webinar coming up. HHS has the discretion of what penalties they might want to do. So they could educate providers, set up enforcement plans to assist them in coming into compliance, or provide those financial penalties. And I have not seen this, but OCR could also work in conjunction with the Department of Justice to avert possible criminal violations of HIPAA. I haven't seen that myself personally, but that would be another avenue of kind of what could happen if something really bad happened, I would think. So as I mentioned earlier, HIPAA is made up of 3 rules: the privacy rule, the security rule, and the breach notification rule. So in this webinar, we're going to focus on the privacy rule, which was the first one. And then we'll have a follow-up one in October where we kind of talk about the other 2. There might be some things that come up, to discuss all of them, but we're going to focus on the privacy rule. It's a pretty thorny rule in and of itself. So I didn't want to fit too much into one webinar. I didn't think we could kind of handle it all. I can barely handle it all. So next. The privacy rule. So it was written to ensure that individual health information is properly protected while allowing the flow of information. So, normally health information before HIPAA didn't flow very well. And then this was a way of improving the flow and the modernization, as I'd said, and kind of trying to provide protection to those patients. And so the privacy rule does apply to providers, health plans, and clearinghouses, which are all considered covered entities, as well as those business associates. And it sets those limits and conditions on the uses and disclosures of PHI without patient authorization and indicates when patient authorization is required. So we'll talk a little bit about consent and authorizations, but the privacy rule sets sort of minimum standards for disclosure of patient information to third parties. And so it kind of talks about the circumstances under which you can disclose, what kind of consent may be needed to disclose, from who is that consent needed, maybe a parent, a healthcare proxy, the patient themselves, when no consent is required for disclosure, and what is the appropriate scope of patient information you can disclose. And I'm going to talk about these all a little bit more as we kind of go through here and kind of try to fill in those blanks. But one thing to always keep in mind with the privacy rule or HIPAA in general is that HIPAA is a federal law. Normally, federal law is what you follow. However, the privacy rule is designed to preserve those state laws that give patients greater privacy or greater right of access or control of their PHI. So it's really important that you be knowledgeable about your state law in addition to HIPAA and kind of how the two interact. This sort of preemption can be a confusing issue, but the risk management consultants at the trust are very good at walking people through that if that is something that comes up for you. So when can you disclose PHI? So privacy rule does not require patient consent or authorization before releasing PHI in connection with sort of routine releases for healthcare information. And this is what they call sort of like TPO, or for healthcare operations, administrative business needs. So for your assistant who needs to call patients, or just send like your billing person in your office who needs to sell the billing. Treatment consultation between healthcare providers does not necessarily require patient consent, and payment purposes. That's that activities to obtain reimbursement, as your billing person might be. And these are things that you would probably have talked to your patient about in that initial session, kind of said, these are the ways that we are going to share your information or use your information in our office. And so you generally would be a good idea to get informed consent, but it's not required. You would want to kind of talk to the patients about how the information might be utilized in the office. It does not, or it does require patient consent or authorization for purposes outside of healthcare operations. So we'll talk about these, but that would be in those instances where maybe a legal proceeding has come up, or anything like that, where you have to get a separate court order or need a separate patient authorization. And there are those certain circumstances where PHI can be disclosed without patient consent or authorization. These are called 512 exceptions, and we'll be talking about those in the next slide. No authorization is generally needed between healthcare patients treating the same patient. If you do not have like a professional relationship with the other provider, then you would need authorization. It's kind of a sticky wicket, but you want to make sure that the patients are basically aware of information that's being shared, but they should generally be consulted about that. So these are the ones that sometimes are very easy and sometimes are a little confusing. So PHI disclosures that are allowed without patient consent or authorization. So covered entities may also use and disclose PHI for certain activities. This is another one where you will want to check your state law. State laws are very different in some of these aspects. And just to make sure that you are still allowed to do these. These permitted disclosures often have accompanying requirements. So you don't simply release information based on my slides, but check the HIPAA rule and state laws. It's important to note that these disclosures are permitted, not required disclosures. So a covered entity may use or disclose protected information without the written authorization of the individual, and the situations kind of covered here. So these are kind of the more common ones, that to avert a serious threat to health or safety of a person or the public, to report abuse, neglect, or domestic violence, judicial and administrative proceedings, that's, subpoenas, court orders, to Department of Health and Human Services to demonstrate HIPAA compliance for purposes of public health. So related to disease, FDA, to a medical examiner or coroner for purpose of identification of the body of a deceased person or the cause of death. And then use or disclosure required by law would be sort of those things mandated by law, which kind of tie into these others, like this, to avert a serious threat or to report abuse. Some additional exceptions that I didn't put on the slide, but that sometimes come up, would be uses and disclosures for health oversight activities authorized by law. So these could be audits, so insurance audits, civil and administrative or criminal investigations, licensure or disciplinary actions. So if your licensing board, if somebody has filed one, you might be permitted to share information there. But like I said, this is permitted, not required. Are other activities necessary for appropriate oversight. So licensing boards I mentioned, this could be another government programs who are ensuring beneficiary eligibility. Disclosures for law enforcement purposes is one that comes up. So you may disclose protected health information for law enforcement purpose to a law enforcement official for like identification and location purposes, basically to maybe information, the minimum necessary information needed to locate a suspect or a fugitive or a missing person. Maybe you need to alert law enforcement of a death of an individual if there's a suspicion that the death resulted from criminal conduct. If there is a crime at your office, or reporting crime and emergency. These are times when you would be permitted to kind of talk to law enforcement without getting a patient authorization. Use and disclosures for research purposes. Some of those of us that work in the federal government, there are for specialized government functions, so fitness for duty, eligibility for VA benefits, national security intelligence questions. Workers' comp is another one that you might not need patient authorization. A covered entity could disclose protected health information as authorized by and to the extent necessary to comply with the laws relating to workers' compensation, especially if the patient is seeing you under workers' compensation and they're paying for it. And so those are kind of the main ones that kind of come up when the exceptions come up for when you need the authorization or not. Like I said, most of these you are permitted, but not required. So generally, if law enforcement is coming to your office, you could give them information if you wanted to, but you're not required. In order, they would need generally a subpoena or court order, and we'll talk about that a little bit, to get information that you aren't willing to release without a patient authorization. So how does a patient authorize that release? So they may consent to share, or they may have to authorize providers to share. So through a patient request or consent to share or release PHI, the privacy rule permits but doesn't require a covered entity voluntarily to obtain patient consent for uses or disclosures of protected health information for treatment, payment, and healthcare operations. Covered entities that do so have complete discretion to design a process that best suits their needs. So that's within your treatment bubble. By contrast, an authorization is required by the privacy rule for uses and disclosures of protected health information not otherwise allowed by the rules. So those are those instances where, must specify, or like, sorry, I lost my train of thought. Patient side authorization form where patient designates who gets information, what information they get, when they get it, and why. So that would be a patient authorizing another provider to get access. Maybe there's a new provider. Anytime you are doing anything outside of that treatment and healthcare. So responding to subpoenas, disability applications, to insurers who are outside of health insurance. So auto insurance, life insurance. That authorization is a more detailed document that gives the covered entity the permission, or that the patient gives the covered entity the permission to use protected health information for specified purposes. So that authorization is going to sort of specify a number of different elements, a description of the PHI to be used and disclosed, the person authorized to make that disclosure, the person to whom the covered entity may make the disclosure, expiration date of it, and in some case, the purpose for which information may be used. You're not able to, or covered entities really should not condition treatment or coverage on the individual providing an authorization. And one of the main things about those authorization forms as well is that expiration date. And so it's really suggested, strongly suggested, that there be a specific timeline and it be very specified in that authorization form of what information they're going to get and why. So this brings us to kind of that minimum necessary that I talked about a little bit earlier. So when disclosing PHI, you're going to want to take efforts to disclose the minimum necessary information needed to accomplish the intended purpose of the use, disclosure, or request. So you've got that authorization saying you've got it, and that authorization should say, like, if it comes for a certain time period, 6 months, you only release the data for those 6 months, even if you've been seeing that patient for longer. In terms of like disclosing it, like office staff that are working for you, they don't need more potentially than contact information to schedule an appointment. And so kind of that minimum necessary for whoever you're dealing with. If it's somebody you're giving records to under HIPAA, what does the authorization say they should have? If it's somebody who works in your office, what actually do they need access to do their job? Minimum necessary doesn't apply when you are consulting with a healthcare provider about treatment. The patient has given that authorization, which should list the specific information to release. Any disclosure to a patient, minimum necessary, you're going to give them everything except for psychotherapy notes, which we're going to talk a little bit more about. Disclosures required by law, as we said, and then disclosures for HIPAA enforcement and compliance. So those disclosures required by law are kind of those public policy concerns that kind of override privacy protection. So those are those ones where it's child abuse, you might have a dangerous patient to self or others, questions of elder abuse, domestic violence, potentially responding to a court order, which is different than responding to a subpoena. Court orders come directly from the judge. They got a stronger, and depending on the state, but they have a little bit of a stronger pull than a subpoena, where you would still go to court and say, I cannot release without patient authorization. Replying to a health oversight agency. So maybe your licensing board or a state health agency. You're going to always want to check your state law to ensure which disclosures are allowed. Different states have different rules about child abuse, dangerous patients, and elder abuse or domestic violence. So in the context of a disclosure or a request for information from an insurance company, it can be a little bit more complicated. The holder of the PHI, or the provider, you are the holder of it for that patient's purposes, gets to determine minimum necessary. However, an insurance company may then refuse to pay the insurance. So it's a bit of a catch-22, but something to think of when you are working with insurance companies. And now I promised we were going to talk about psychotherapy notes. Some people keep psychotherapy notes, some people don't. They are optional notes kept from a private therapy session that may contain highly sensitive PHI and serve as private notes for your own use. Now, a caveat, some states may grant patients unfettered access to their entire record, which would preempt a therapist's capacity to sequester those notes away. So for HIPAA, those notes must be kept separate to qualify for that special protection, labeled in a way that you can determine which is which. It can't just be kind of like one is like all in the same file with no notes to separate them. You're not allowed to later on say, oh, this one's a psychotherapy note, this one's a regular note. So you really need to make them specially separated and in a way that makes sense. But like I said, if states say we don't allow that, then that the patient gets access, then the patient would get access. So you're going to really want to look. And some states use other terminology. So I've seen process notes. I've seen psychotherapy. I've seen some states with progress, psychotherapy, and process notes. So you're going to want to kind of check your state law and see what it says about kind of managing that. Commercial insurers and patients cannot generally have access to the notes, like I said, outside of state law. Psychotherapy notes cannot have to exclude sort of medication prescriptions monitoring, which depending on your profession, you might not have a lot of that. You might just have them noted. You might be a prescriber. Sessions start and stop times have to be in a regular note, not a psychotherapy note. Type and frequency of prescriptions, clinical tests, summary diagnosis, functional status, treatment plans, symptoms, prognosis, and progress to date. These are all things that need to be in your regular clinical record. They're going to be part of insurance. They're going to be things that your patient might request when they want it. So the psychotherapy notes would be the more highly sensitive, sort of your thinking notes, or the notes that are your private thoughts. And I use that kind of cautiously. I think, the key point is, though, even though psychotherapy notes have that protection under HIPAA, they are potentially available to someone. And then, so you should take some care and kind of making those notes, you really want to be knowledgeable about your state's laws for patient access. If the state offers more information to the patient than HIPAA, i.e. access to the psychotherapy notes, the state law will win out and the patient could get those. So it's one of those ones where you might want to be a little careful about what you do put in them if you're not sure what your state law is. Sort of that rule of don't write anything down that you wouldn't want somebody to be able to read. And so now I want to talk about kind of those patient rights under HIPAA. And so I'm going to talk mainly about, I'm going to go through all of these. The right of access is the big one. So we're going to talk quite a bit more about that. But basically under the privacy rule, patients have the right to get notice about potential uses and disclosures of PHI. So that would be personal representatives who stand in the shoes of minors, incapacitated adults, and deceased patients. They get notice. Those potential uses and disclosures would not necessarily be the traditional treatment operations ones. It's not disclosures that involve you submitting billing statements or a list of all of those. These would be more the disclosures that you would talk to them about that involve sort of an inappropriate breach. Somebody got into the records, or you submitted a disclosure to a court order or anything like that. So these are going to be the more unusual or outstanding, not the traditional just healthcare related consults and disclosures. Patients always have a right to amend. So they can request an amendment if they feel information in the record is incorrect or incomplete, but it's up to the provider as to whether the amendment will be accepted. So generally you would not alter the original record, just add a potential statement or inclusion of a statement to the record. But like I said, the provider could determine that they don't want to add it in. It's kind of on a case-by-case basis. And then the right to an accounting of disclosures. So that kind of gets that back to that sort of where is your information gone? And it doesn't cover, you know, I shared your information with Dr. Joe because I'm working on the mental health and Dr. Joe is working on your endocrinology. You know, you're part of a clinical team. Those disclosures are believed to be kind of general, and if you've done the informed consent with your patient at the beginning, kind of normal. It's more of those outstanding ones. And so the right of access, I didn't do a separate slide on this, and I was mentioning that I wish I had. I think this is a big one. So right now there is quite a lot of, there's quite a lot in the news about right of access. So the privacy rule generally requires HIPAA covered entities to provide individuals upon request with access to their protected health information. That includes a right to inspect or obtain or copy the PHI, or both. Maybe they want to inspect and get a copy, as well as to direct the covered entity, the provider, to transmit a copy to a designated person or entity of the individual's choice. So individuals have a right to access that PHI for as long as the information is maintained by the covered entity or by a business associate on behalf of the covered entity, regardless of when it was created. Now, some states have rules about record keeping. HIPAA does not necessarily speak to how long you must keep records. So you're going to want to look at your state law for that. But that could be quite a long period of time, right? That they could, a patient of yours that you've been seeing for 6 years could come in and say, I want my PHI for the last 6 years. So it's just important to kind of keep that in mind. And it's sort of they can get it in whatever, they generally can ask for it in whatever format that they require or they request. But there are some sort of aspects there, like obviously if a patient is asking for something electronically, you're going to try to give it to them electronically unless it's, you know, obsessive or not obsessive, impossible to do so. So the privacy rule does kind of require that access to the PHI in the form and format requested, if possible, if it's readily producible. So if you are not able, let's say you only have the records in paper and they wanted an electronic, if you really cannot, it has to be in a readable hard copy form or other form, but then the patient has to agree to that. So some providers might try to take that attempt to sort of scan all that information into a system or into an EHR. And that's kind of part of the move towards more of technology in practice. When a patient asks for their record, you must provide access to the PHI requested in whole or in part, no later than 30 calendar days from receiving the request. So that's the outer limit. You're encouraged to respond as quickly as possible. So if you can provide it quicker, or if you are in an EHR and can do it instantaneously, or within a couple of days, it's suggested that you do so. If you're unable to provide access within that 30 calendar days, maybe the information is archived offsite, or some emergency happens in your family and unfortunately you can extend the time but no more than by an additional 30 days. So in order to do that, you must inform that patient in writing of the reason for the delay and the date by which you give access. And you're only allowed that one extension. So now that I'd mentioned before that there's that notice of proposed rulemaking out there that we're still kind of waiting. One of the changes of that notice of proposed rulemaking is to provide greater access to the records. And part of that is they're proposing to amend it from a 30-day process to provide access to a 15-day. So it would drop it down from 60 days total if you need that extension to 30 days total. You'd get the 15 days and then the 15-day sort of extension at the end. But that, like I said, we don't know where that is right now. So right now it's, if you have 30 days from the request to get the records, and it's suggested that you do it earlier in it versus later. Fees, when a patient does request access to the records, you can go ahead and ask for fees, allowed for labor for copying, not searching for the PHI. They're not going to allow that. But labor for the copying, there might be, this is one that I think would probably be allowed. It's a little bit of a gray area, but scanning them in. If your records are all paper, the patient asks for an electronic version, it's kind of the same, right? Labor for copying a paper copy or labor for scanning it in to make an electronic copy. Materials, so if you have to purchase paper, if you potentially have to purchase a thumb drive or something like that to provide, but that would be something you're going to want to look at your state law. Postage, if you're mailing it to the client, and then preparation of a summary. So you can offer, when a patient asks, you can offer them a summary in lieu of them actually getting the full record. And if a patient agrees to that, that's great. But if they say, no, I don't want a summary, then you give them the full one. And if they say, okay, yeah, I'd like a summary, then you can generally charge a small fee for that. But again, that's going to be dependent on state laws. You're going to want to make sure you look into that. I feel like I keep saying that over and over again, but it's the beauty of HIPAA. It's state and federal law working together. So the reason I kind of focused a lot more on this right of access right there is one of the Office of Civil Rights, OCR's main initiatives the last couple of years has been about right of access. They're trying to demonstrate the commitment to ensuring that individuals have the right to timely and affordable access to all of their protected health information contained in designated record sets. And so, under the patient right of access, some things to think about: all covered entities would be at risk for noncompliance. Let's say you're unable to get the records in 30 days and 60 days, or you don't get the records to the patient, that could be noncompliance. It's important that you accurately describe that right of access in your notice of privacy practices, that form that you all probably have had since 2003 at least, that kind of tells the patients what it is, even though nobody maybe reads it. It should say the right of access, that they have a right to get access to whatever records that it would be implied in your state law. And then that 30 days. remembering that the personal representative can stand in the shoes of a patient. So if a parent is coming in requesting access for their, maybe juvenile child or adult child that does not have capacity, or anything like that, or a person coming in after a patient has died, they stand in the shoes of the patient, they can get that access. And then ensure it is possible to access the record set. So this kind of speaks to where you save your records. And if you do save them off-site, how do you have them organized? Are they easy to find? Are they easy to get set up? Cloud computing services, there's some really great ones out there. And it's a matter of knowing where the information is and how you access it. And then you want to track those requests and responses to requests for access. It's important to kind of make sure that you're keeping track of that as part of the disclosures, and HHS, if they were to come in, or OCR in this instance, were to come in, they want to know that this information is being sort of submitted or sent out or being tracked. Covered entities must document record sets. That's sort of that information I talked about earlier, treatment, prescriptions, plans, etc. Document the persons responsible for receiving or processing requests. So if you're a sole provider, you're going to want to document that you are the person responsible. If you have somebody in your office who is the go-to person for these requests, that's who you're going to list as your person in charge. And these might be internal documents that you just keep of the logistics of how your office runs, but OCR would want to see that information if they were ever to come in, do a spot check. And then covered entities have to provide access to that PHI, as I said, kind of as requested by patients and personal reps. There's only a few ways that you can kind of deny access. Maybe if it's going to endanger the life of a patient or another patient or cause substantial harm. Some ways to deny would be if you are working in a correctional facility and to release the records could potentially put another inmate or a correctional officer at harm. And there's different, there's other aspects of kind of if you have gotten PHI, let's say from a family member, and it would put the family member in harm's way if the patient were to have learned of this, that could be another reason to deny. But the harm has to be reasonably likely to endanger the life or psychological safety of a person, of an individual or another person, and does not extend to concerns about psychological safety. It's more of that, that there could be a physical event happening. Any denials that you do, the patient has to generally be given a right to have those reviewed by another another healthcare professional. And so that healthcare professional should review your decision first and give a second opinion. HIPAA sets a very high bar to limit or withhold the PHI from a patient. So the HIPAA rule is generally going to preempt most state laws for records. That would be one of those ones where the patient would be able to get more access. However, in the case of like minors, the access to a minors, HIPAA would generally defer to the state law with regard to who can access sort of that minors protected health information. So it's important to kind of remember that while providers are custodians of PHI, they're not the sole owners of that information. And so it's necessary to remember that an individual's access is protected under HIPAA, and providers should make those attempts to comply with those requests under the provider's control. As I mentioned, OCR's right of access initiative demonstrates they're taking this pretty seriously, that patient's right to timely access. There have been a number of large settlements recently related to this. And so that's just one important thing to kind of keep in mind. And with that, I think I'm sort of at my questions slide. So I'm not sure. I went through that a little faster than I planned, but it gives us time for questions.
It does, and we do have a lot of questions. So
Oh, goody.
thank you very, very much. We appreciate your attention to detail. And some of the questions will actually repeat some of the things that you may have already said, but as my homeroom high school teacher used to say, repetition is the mother of learning.
Right.
But let's go back to the very beginning of the presentation. You talked about things that might trigger HIPAA. What do you mean by trigger HIPAA?
So trigger is sort of this idea that there are some providers that might never use or do any sort of administrative or financial transaction in an electronic form. You might never bill insurance. You might never email an insurance company. Those providers might not need to comply with HIPAA. But if you are one of those providers that has conducted those sort of electronic transactions, transmitting email or information, PHI, through email to cloud storage, or submitting questions or making transactions on insurance company websites. That's what I mean by triggering. You have to kind of do those certain administrative or financial transactions in an electronic form.
Right. So anything that then would cause HIPAA to apply to your situation.
Yeah.
So, yeah. Okay, here's another one. If a BAA form for a company doesn't require my signature or date, but is signed by the company or representative, is the BAA valid?
So I'm assuming this is a B. So that's kind of a trick question. It could be, it might not be.
Okay.
Generally, it would depend. A lot of bigger companies have their own business associate agreements, and they might have them sent to you and everything. You might not need to sign them. But from another perspective, it makes sense to have both parties sign. So it would it would really depend on the BAA, truthfully, kind of how it reads. And then you'd want to know kind of, is there expiration dates or anything on that, and kind of the language, if they're the only one signing, what holds you to that agreement, what holds them to that agreement, kind of how does the agreement end if you haven't signed it? Those are a couple of questions that would come up to me, but without seeing it, I'm not quite sure.
Of course. What about, so someone who provides self-pay services, but sends invoices or PHI via email, is that a covered entity?
So it would depend on where they're sending the PHI. So self-pay.
I would assume it's via email to the patient.
Right. So technically it's, that would be what I would consider like sort of that administrative transaction. And I would say that you are triggering HIPAA if you're sending electronic information to your patients, even if they're self-pay. But so yes, I would think that would trigger HIPAA.
Okay. Is there any provision in HIPAA that PHI cannot be stored in a cloud offshore?
I have not seen one. Some things to be considered. I mean, a lot of the times we're not sure where the clouds are. So I guess offshore, I would wonder, does that mean like in another country? Do you just mean like offshore, like on a ship? So, I haven't seen that there is any provision that you can't, but it is important to kind of look into those, research those cloud services when you are deciding on them, and determine kind of how the different laws apply. HIPAA is a law here in the States. It's not necessarily a law over in Europe. And so while you can say, you're my business associate, you have to follow this, there's a question of if they could actually like say, well, we don't need to because we don't follow HIPAA. So that's something to keep in mind. I'm not sure when you mean offshore, if it's kind of like another country or whatever, but I would say it's probably better to try to stay within the boundaries of the United States when it comes to complying with just federal law.
Okay. And another one. Do I need to have a signed release from a patient in order to speak with the patient's psychiatrist if we do not work within the same agency or office?
So in that instance, that would be for treatment operations. So you wouldn't necessarily need a signed release. It's not a bad idea to have one, but you would want to at least get the patient's consent that you can talk to that other provider. Consent can be verbal. It doesn't always need to be written, but I generally, when I do that, I would even document it in my notes that the patient said I could speak to that provider. And it's not a bad idea to have those releases just to, as a protective measure. But you don't need a formal authorization generally if it's a treatment team kind of discussion.
Okay, and this kind of follows along that a little bit differently. May a patient email a typed as opposed to signed authorization, as long as the email includes the purpose, expiration, etc.
I'm not sure I understand.
So instead of a signature, it is a type. You type in, the patient types in his or her name instead of doing a signature. Is that considered authorization?
In this day and age of kind of having to do electronic signatures, I would say that in that instance, I would probably be more amenable to like the PDF signatures where you kind of have some sort of protection of that. I would be slightly worried. And obviously with these authorization forms, you're going to be talking to your patient, but I'd be slightly worried that somebody would have, and this is my lawyer brain, somebody has nefarious, dealings and they type in a name and it's not actually from the patient. So I think it's sort of, it's a bigger protection if they can do it like PDF form, where you kind of have that sort of protection of it's being electronically signed on a PDF, like DocuSign or one of those programs. If not, then I would say, I would strongly recommend that you document that you spoke to the patient, that you verified that this is their typed signature, that sort of thing, just to give you that additional protection.
And might it also be a good idea in an informed consent to include in there that the patient agrees that a typed signature stands in their view as documentation and as a real signature, so that there is some coverage there that it was discussed beforehand. So
yes, I agree. Yeah.
We have time for about one more question. Who owns my mandated reports? Does a subpoena for records include these?
So it depends on what the mandated reports are. So if you are in a session and somebody has reported to you child abuse, that they're abusing a child or they're a victim of child abuse, that's going to go to your state's DCYF or things like that. So that's who you're reporting those to. A subpoena is generally coming from an attorney. Some states it comes from a judge, but mostly they're coming from an attorney and they're requesting your records for some sort of legal proceeding. So they're slightly, I get that they're together, but they're slightly different beasts in that context. I don't know if I answered that question, but
yeah. Well, I want to thank you again on behalf of all of those who attended. That this was certainly, this is the kind of thing that makes our brains hurt sometimes. Because it does seem to be complicated, but you outlined it very clearly for us. And we do look forward to part 2. So thank you very much, Dr. Larson. We really appreciate it.
Thank you. I had a great time.